Ladies and gentlemen, join us on a legal journey as we explore the intricate world of omissions in the realm of law, a failure to act that carries distinct legal consequences, differing from positive actions.
In the realm of criminal law, an omission becomes significant when it constitutes an actus reus, and results in liability only if there exists a legal duty to act, which the defendant breaches. Historically, the common law did not impose a general duty of care toward fellow citizens, as famously illustrated in the scenario of watching someone drown without attempting a rescue. However, legislatures and courts have stepped in to criminalize such omissions when they are morally reprehensible or sufficiently blameworthy. Some statutes define the actus reus as act or omission, reflecting the dual nature of liability.
For instance, imagine an individual witnessing a child in a pool with a depth of just 6 inches, a nearby flotation device, or carrying a mobile phone that could summon help. In such cases, the law may impose liability for failing to act. However, the law does not require individuals to risk their own lives, even if they are lifeguards patrolling a beach, river, or pool. An employee, regardless of their job, cannot be compelled to do more than what is reasonable in the given circumstances.
In a landmark case, R v. Dytham, 1979, QB 722, an on-duty police officer observed a man being beaten to death outside a nightclub and left without calling for assistance or an ambulance, resulting in a conviction for willful misconduct in public office. This case exemplifies that an omission can lead to criminal liability when it involves deliberate failure and willful neglect that injures the public interest.
In another case, the Attorney General's reference, number 3 of 2003, 2004, EWCA Crim 868, police officers arrested a man for a breach of the peace due to his abusive behavior toward hospital staff. The man later stopped breathing in the police station, and 5 police officers were charged with manslaughter by gross negligence and misconduct in a public office. This case clarified the elements required to establish the mens rea of the offense, emphasizing that the defendant must be aware of the duty to act or subjectively reckless regarding its existence.
Moving forward, let's explore situations where individuals assume responsibility for the care of dependents. In general, parents, legal guardians, spouses, and those who voluntarily care for dependent individuals may incur a duty to act. 3 cases illustrate this principle.
In RV Inston 18931 QB 450, a woman living with her aunt failed to feed her or call for medical help when her aunt fell ill, resulting in a manslaughter conviction.
In R v. Stone and Dobinson, 1977, QB 354, a couple caring for a woman with anorexia failed to summon help, leading to a manslaughter conviction.
In R v. Gibbons and Proctor 191813 CR App Rep 134, a father and his lover neglected their child, resulting in a conviction due to their obligation to care for her.
Our journey also delves into statutory omissions, where certain offenses involve a failure to comply with a duty to disclose specific actions. For example, S-19-2 of the Terrorism Act 2000 and failure to disclose knowledge or suspicion of money laundering maintain this tradition. In some instances, omission can even constitute an offense, as seen in S-170 of the Road Traffic Act 1988 for failing to report a road traffic accident.
Now let's explore the duty to act when an individual has created a dangerous situation. A person who initiates a dangerous scenario may have a duty to take reasonable steps to prevent harm. In R v. Miller 19832 Ac 161, a defendant's failure to act, after inadvertently causing a fire, led to a conviction under the Criminal Damage Act 1971.
However, when it comes to constructive manslaughter, as seen in R v. Lowe, 1973, QB 702, a distinction exists between commission and omission. Mere neglect, even if deliberate, does not suffice for constructive manslaughter unless it constitutes a breach of duty to act. This principle was reaffirmed in R v. Kahn and Kahn, 1998, CLR 830.
Our journey further explores situations where medical treatment is omitted. Doctors and hospitals generally have a duty to provide appropriate care, except when an adult patient with ordinary capacity refuses consent, the conflict arises between patient autonomy and society's interest in preserving human life. Courts have upheld the right of individuals to refuse treatment, as demonstrated in Re C, Adult Refusal of Treatment, 19941 WLR 290 and Re B, Adult Refusal of Medical Treatment 2002, 2 Air 449, emphasizing the importance of understanding the patient's capacity and the likely consequences of treatment.
In death with dignity scenarios where patients cannot communicate their wishes, doctors may be relieved of the duty, as recognized in Airedale National Health Service Trust v. Bland, 1993, AC 789. This case established a distinction between acts and omissions, highlighting that an act intentionally causing death differs from an omission that leads to the cessation of ongoing treatment.
Lastly, we explore the duty to act when contracted to do so, as illustrated in R v. Pitwood, 1902, where a failure to fulfill a contractual duty led to a conviction for gross negligence manslaughter. In the realm of war crimes, international law introduced the concept of command responsibility, holding military commanders individually responsible for war crimes committed by their forces when they fail to prevent or prosecute such crimes.
And there you have it, a comprehensive exploration of the complex world of omissions in the realm of law.